Archiving started.
Welcome to Chapter 6, which will cover legal research and analysis. I have 2 PowerPoint presentations on this chapter. This portion covers the first 6 slides of Chapter 6, and the second presentation covers the rest of Chapter 6. So let's begin. And I guess a good place to begin with legal research is discussing how do you begin a legal research project. Before we talk about the substance, let me remind you that we have a course in the paralegal program called Legal Research. It's LGLA 1303. Many of y'all are probably taking LGLA 1303 right now. If you're not taking it this semester, you'll probably take it the next semester or perhaps the semester after that. In that course, we talk about these issues that we're going to be discussing for the next week or two in great detail. The purpose of this chapter and the next one in the textbook is really just to introduce you to those topics. Many of the tools that we talk about in this chapter and the next chapter will actually be very hands-on in LGLA 1303. So don't expect that all of your questions will be answered or that you'll have a robust understanding of everything relating to legal research. This is really just to kind of put your big toe in the water, to kind of know some of the big concepts, to start thinking like a legal researcher, and then when you take LGLA 1303, you'll be ready to dive in and know what to expect and kind of have some mental framework to think about the issues. So let's consider, how do you begin? Well, obviously, when you start a legal research project, you have some type of question or some type of topic to research. But many times you may leave the assigning attorney's office and think that you understand what the issue is. It may be an area of the law that you're not that familiar with, and so when you dive into the issue, or when you think about it, you think, okay, I know what to look for. But when you start actually looking at the statutes and the cases and the other secondary resources, you may start thinking, well, was it an issue that was, we'll say, this big, or was it something that was more this big? You may not be sure of the scope of what you're supposed to look into. And so, or you may think, well, I think it was this issue, but it might have been kind of this issue. So you may not be sure, does it include this area? Does it include this area? And so you may, once you dive in, realize, hey, I wasn't quite as clear as I initially thought I was. And that's why it's so important to keep regular communication with the assigning attorney open. The attorney, when he or she assigns a project to you, probably has this attitude. And I'm going to be honest with you. I'm not going to sugarcoat it. Imagine for a second that you have more work than you know what to do with. And you have somebody to whom you can delegate work. And you trust this person. You know this person has good judgment and good skills in this area. So what you might do when you think about this issue is you might think to yourself, well, I have these 50 things I've got to do. It would be great if I could move 5 of those things to someone else's desk. And then it's not my problem anymore. I mean, it's still my problem to some extent, but I have moved it to somebody else's desk. And so now I only have 46 things I have to worry about. I'm still overwhelmed. I still have more than I know what to do with, but I only have 46 now instead of 51. Very likely the attorney is looking at this way. Very likely the attorney also has not thought in depth about all of the particular issues that might come up in your research. He or she may be thinking, I think the issue is about this size. But really, if he had done the research, he would realize the issue is really this size. Or maybe he would discover it's more this size. Or maybe it's more this size. The point I'm trying to make is he may not have thought deeply or carefully about the issue. And even if he has, he may not have done any kind of research into the topic. So you don't know what you're going to find until you find it. And so he may be belaboring or laboring under some assumptions that don't end up being correct. So when you are doing research, understand that a baton is being passed to you. You are being entrusted with something, which is very flattering. But it is also, it should be a little bit scary. You ought to think a little bit to yourself, I am now responsible for this. And so it's my job to do a good job. It's my job to understand what I'm supposed to do and to complete it in a satisfactory manner in a satisfactory period of time. And that's going to require that you take ownership of it, and it's going to require that you be proactive. It may mean that you need to go back to the attorney and say, hey, I thought I understood, but when I started researching, I wasn't clear whether you wanted me to research this part of the issue or whether you wanted me to research this part of the issue. Better that you go back and ask the attorney than you end up doing this part and the attorney wanted you to do this part. Because, number one, you will have spent time, which is client's money, and you can't kind of unring that bell. I mean, certainly the time can be written off, but that's time that your employer was paying for your services, so that's not efficient. A time for an attorney and a paralegal is, imagine a widgets factory or a bakery that turns out loaves of bread. Well, the minutes that you spend working on a project is like loaves of bread in a bakery, and you don't want to produce, if you're running a bakery, you don't want to produce a lot of loaves of bread that don't have yeast in it or don't have the right formulation, so they have to be thrown away. If you have to write off your time, or if you spend time doing something that isn't ultimately in the client's interest or the client hasn't approved, well, under those circumstances, it's like you're having to throw loaves of bread away. That doesn't make sense. That's not going to get you a good reputation in a law firm. But it can be even more serious than having your time written off. If the attorney says, I need an answer by Monday, he might need the answer because he's meeting with the client, and the client expects an answer. Well, if you've answered this question, but the actual question you're supposed to answer is this, then you meet with the attorney that morning, and he says, wait a second, that's not what I needed the answer for. And now it's too late for you to find the answer. And so the attorney's going to have to meet with the client saying, I don't know. I don't know yet. I'll find out, but I don't know yet. That's not an impressive thing to have happen. Or it may even be more serious. It may be that something has to be filed with the court, or a strategic decision has to be made, and a decision has to be made that day, whether you know the answer or not. And so the client's options may not be adequately be able to be adequately explained to the client, so the client is going to have to make decisions without the level of knowledge that he or she would like. Again, not very impressive, and you're not meeting the client's needs. So even though it may be uncomfortable for you to go back to the attorney and say, I don't know, I thought I knew, but I don't, that's kind of embarrassing. That's not a very comfortable conversation. He or she entrusted this to you, and he or she entrusted that you would go back to him or her when questions arise. So you ought to feel comfortable. You ought to feel empowered to have that conversation. Now, I will alert you to a couple of things. You shouldn't be going back into the attorney's office every 15 minutes. Oh, wait a second, I got one more question. Oh, well, what about this? Oh, well, what about this? You ought to save up questions. You ought to see if you can get the answers through other sources if they're available. For example, let's say that you have some questions that if you were to review the file, you'd be able to find out, oh, yes, that's Bob's Social Security number, or yes, that is Mary's date of birth, or whatever, without necessarily having to go to the attorney. But there will be some questions that you will have to get from the attorney because only the attorney knows exactly what needs to be researched. But you want to make sure that you can clearly and precisely ask the question. You're not going to have to go back repeatedly because, again, the attorney has passed the baton to you. He is working on those other 46 projects while you're working on those 5 projects. And so the more times you have to stop in, the more you're distracting him or her from the other work that he or she has to perform. So you want to be respectful about his or her time. You need to have the conversation, but you don't want to eat up more time than is necessary. It may also be the attorney's out of pocket. He or she may be traveling or in court or meeting with clients or doing other things that are really not able to be interrupted. So you want to consider when the attorney will be available for that contact. Another useful thing to consider, and this is very helpful during the interview, is to repeat to the attorney what you feel the attorney has said to you. Something like this. Thanks, Bob, for the assignment. Let me just make sure I've gotten the key facts. Bob was in a car accident with Mary. Bob is suing Mary, and there's a question about the statutory period. This is when the accident happened, and this is da-da-da. And you list briefly the facts that you have, and then you say what you think the issue is. That gives the attorney the opportunity to say, oh, that's not quite right, or, oh, you got one of these facts wrong, or, well, actually, it's that question, but it's also this one. It may be that you've said it exactly the way the attorney has said it, but when he or she hears it repeated, he or she realizes, well, I need a little bit more, or maybe not quite that much. So you're helping the attorney shape the question that he or she may have. Sometimes it's useful to put this in an email, and it can be useful in a couple of ways. Number one, it can give the attorney a point of reference. Maybe he or she is traveling, they can pause over it and think, oh yeah, let me make sure I've got this right. Sometimes seeing it in writing, having a bit of time to review or reflect it, can cause the attorney to say, oh, no, wait a second, I think you're going to need to know this other fact, or, well, yeah, I want the answer to that question, but it would also be great if you could answer this related question. Another benefit to sending an email is that it gives you a permanent record. It can be your notes for the project. One thing that I found in my legal research is sometimes I would be doing a legal research project, and there would be so many issues all kind of lumped together, and I would start researching, say, this issue, which is so closely related to this issue, and maybe I'd find this issue interesting too. And so my project would morph into this bigger issue. Now, maybe the attorney did want to know the answer to both these questions, or it could be that the attorney already knows the answer to this question, or it may not be that relevant to this case, or maybe someone else is doing that research. So it's not smart for me to assume that I ought to take on the additional issue. I need to confirm that with the attorney to make sure I'm not spinning my wheels, wasting my time. If you have in a 3x5 card or an email message precisely what the question is, as you're doing your research, you can refer to it and say, now, wait a second. Is this case that I'm reading helping me answer this 25-word question that I'm supposed to be answering? And just putting it down on paper, black and white, can help you focus your attention. And again, sometimes I literally would put it on a 3x5 index card, put it in front of me so I could periodically look and say, now, wait a second. Is this case helping me with this question? Or is it kind of a nice-to-know, kind of related topic? And so that can be a helpful mechanism to do that. Sometimes sending the email confirmation, though, can be a little bit dicey. We're not going to talk a lot about office politics in this course, but I think it's useful to be aware that whenever you're dealing with other people, especially I think in a business environment, whether you become a paralegal or an attorney or an engineer or a plumber or whatever you decide to become, you're going to deal with people. And there's going to be interpersonal issues that can sometimes create some dynamics that may be unexpected. And I will give you an example of one. If I were to get an email from a paralegal, if I'm the attorney and I get an email from a paralegal and she summarizes what we've just talked about, I might think, wow, she's proactive. She's written this nice summary. I love having this information. I can review it at my leisure. This is wonderful. This is professional. I'm loving this. That might be one reaction. Another reaction that I might have, depending upon the different demographics, but the dynamics in my work environment, is that I might feel that this is a CYA type, cover your backside type thing that is happening here, and that the paralegal is kind of documenting our conversation. So she has a paper trail, and that implies that there isn't a lot of trust going on. Or perhaps this paralegal has heard, oh, well, Groover gives you an assignment, but then she changes it. She never tells you. So you better document what it is. So it can be interpreted in a positive light. It can be interpreted in a negative light. And it's useful to consider those dynamics. If it's a relationship that is comfortable and well-established, you might find it useful to send an email. If it's not, and you don't know this person well, it might be useful to say, hey, would it be helpful if I sent you an email so make sure we're on the same page? And if they say, oh, no, don't do that, or I don't think that would be helpful, then, of course, you know not to do that. If you get permission and you send it, then, how can someone be mad under those circumstances? So that's just something to think about. And in a larger sense, it's always helpful to think about what are the alternative interpretations of what I'm doing. I plan on accomplishing A, but could somebody think I'm trying to accomplish something other than A by my actions? So we've talked about defining the issue. We've talked about confirming the facts that you know. And as you're researching, there may be a situation that you didn't know enough. The attorney assigning the matter didn't realize what you needed to know in order to complete the assignment. After all, he or she hadn't done the research. If he or she had done the research, he or she wouldn't need you to do the research. So he or she may not have anticipated everything that you need to know. So it's pretty common for you to need to say, hey, wait a second, you didn't tell me this, and I need to know this in order to come up with an answer that's going to make sense. And again, there's a couple ways it can be approached. More and more law firms are going to a paperless environment where the files are maintained electronically. And so you may be able to get access to the whole electronic file, and you may not need to talk to the attorney at all. Some law firms keep some things electronically, but keep a lot of things still in paper format. So you might need to go to the person who is responsible for that file. It may be kept in the attorney's office, but his or her secretary might have the ability to get it. Or if he or she has a regular paralegal assigned to him or her that's not you, that paralegal may be able to get you the file. Also, it may be maintained in a file room where a file clerk or a receptionist or some other office person is able to get you the file. So you may be able to access it directly without interrupting the attorney. Now, again, this can be a touchy subject. Some people are very protective of their files, and that's understandable because there's confidential information in there. Moreover, if somebody takes the file and loses it or misplaces certain parts of it, that can cause a lot of heartache in litigation or in any matter. So you can see why someone might be protective of the file, so don't be surprised if you're not given automatic access to the file and that you need to go through someone else to get information. So again, be flexible. Remain in contact with the attorney to make sure you're not straying from the assigned project, but don't become a pest. You might want to look for times. Let's say you talk with the attorney Monday morning and he needs an answer by Wednesday, or so we'll say by Thursday at noon. So you might want to say, would it be appropriate for me to touch base with you tomorrow at 4 just to make sure I'm on the right track? And, then you might go say, I'm in meetings then. Well, how about at 2? 2 would work. Come by in. I only have a couple minutes then, but why don't we talk then? And so having a pre-scheduled time, or at least a time where if you have questions you might be able to get some resolution, can be helpful. Another thing to keep in mind is that each research project is different. When I've gotten research projects, and when I began my career, certainly I was the one who was not assigning projects but was receiving projects. And I don't think I ever got a single research project that was as straightforward as the assigning attorney thought it was going to be. After all, when you haven't done the research, you can't anticipate all the twists and turns that the law takes in this area. It seems like it's probably going to be a straight shoot, right? There's going to be a case that gives you that answer clearly and succinctly. Well, as I say, you rarely get in that situation. I'm not going to say never, but usually if the attorney thinks it's going to be a 2 or 3 hour project, it's probably going to be more like 3 or 4 hours. If he says it's going to be 5, it's probably going to be 7. At least that's my experience. The people usually underestimate. They don't anticipate all the problems that might come up. But each research project is different. And as you are completing your time record, you certainly should bill all the time that you spent on the matter. But you also ought to be prepared to be questioned. Well, why did it take you 7 hours instead of 5? And be able to say, well, this is what I encountered. These are the reasons, I didn't find a statute on point. I had to find cases, and I ended up needing to look at 20 cases in order to decide that this was the answer that I need to have. So be prepared, not in a defensive manner, but be prepared to explain your methodology, what you looked at, and why you need to look at those tools. Another reason the attorney may ask that type of information is to confirm that you looked everywhere you needed to. If you only looked at statutes, and especially if you didn't find a statute on point, the attorney's certainly going to say, well, what about case law? If you looked at case law but you never found a statute and the attorney thinks there might be a statute in the area, then he's going to say, well, did you look? Where did you look? How do you know there isn't a statute on point? Because the attorney is ultimately responsible for the thoroughness and completeness of the work. The paralegal can do the legal research, but the attorney ultimately is the one who has to sign off on it. Let me pause here and talk about a related topic that I probably should have begun with the introduction with. We've already talked in this course how a paralegal can do virtually anything that an attorney can do as long as the paralegal is supervised by the attorney. There are some exceptions. For example, a paralegal can't appear in court, can't take a deposition, can't give legal advice, can't establish an attorney-client relationship. But for the most part, 95 or more % of the work that an attorney can do, a paralegal can do as long as the paralegal is supervised adequately by the attorney. Well, the supervision is a big deal. And so when the attorney gives an instruction to the paralegal, he is saying, I'm trusting my law license to you. I'm trusting that you're not going to screw up and get me disbarred or get me disciplined or result in me having a big malpractice claim against me. So he appropriately is going to say, well, where'd you look? He's going to ask you the same questions he would ask himself if he were doing the legal research. And if he finds that there's a hole, hey, you didn't look there or you didn't look here closely enough, that doesn't necessarily mean that he's mad at you or that you didn't do a good job. Perhaps because of his greater knowledge of the law, he is more attuned to where the holes might be. So think of this more as a learning moment than as criticism when he challenges you and says, oh, you need to go back and look in that area, or I'm going to look in that area, or let's look at that area together. Sometimes paralegals think, well, I can't do legal research because after all, that's giving legal advice. Well, it is, because naturally when you do legal research, you're finding out what the law says and applying the law to the facts of your client's circumstance. So more often than not, in the vast majority of cases, it does involve the development of legal research, legal advice. Legal research largely is synonymous with legal advice, and we all know paralegals can't give legal advice. So you may be thinking that I shouldn't be doing legal research. Not at all. Paralegals routinely give legal advice. The problem is not with giving legal advice. The problem is who the legal advice is given to. If a paralegal never gave legal advice, really all he or she would be then, and I think no criticism of legal secretaries, but that would be the function that he or she performed. The reason that paralegals can give legal advice and do legal research is that the paralegal does not give the information directly to the client or to the court or to opposing counsel or anyone outside the law firm. Instead, the paralegal gives the legal advice to the attorney, and the attorney is in a position to evaluate it. When the paralegal drafts a contract, that is giving legal advice. It's saying that I think that this contract will meet our client's needs. And then the attorney reviews and goes, I don't think so. I think this paragraph needs to be changed in these ways. Or, you did a great job. This is exactly what we need. So it magically becomes the attorney's legal advice, assuming the attorney has agreed to it. So there is no problem with the paralegal producing legal research or any other type of legal advice as long as it goes to the attorney before it is shared outside the law firm. Let me talk about one more issue on this slide, and that is, let me clean this up a little bit, that each researcher has a different approach to legal research. Legal research, I think, is pretty similar to writing. We all have different approaches. I know some people who are very big into coming up with outlines of legal research, of writing. I know other people who just start writing. There's lots of different approaches, and there probably are better ways and less good ways. There are probably ways that are especially useful for someone beginning. Certainly those things are true, but at the end of the day, if you were to talk to 20 really good legal writers, you'd probably find they have 20 different approaches. And the same way with legal research. Each researcher has a bit different approach. Some people love this particular resource, others love another resource. The resources that you like oftentimes depend upon the resources that your law firm has. Or it could be the particular practice area that you engage in the particular state where you engage in it. So there's lots of different factors. So you can't really say, well, every single time you do a legal research project, you ought to do A first, and then you ought to do B, and then you ought to do C. There are some general rules that we'll talk about, kind of rules of thumbs that are going to be helpful, but you shouldn't think to yourself, this is always going to work, this is always the path that I ought to take. Although it's helpful when you start a new project, especially if it's an area of law that you're not really familiar with, is to say to the attorney, where do you recommend I look first? Because many times he or she will have some ideas. Here are some examples of legal issues that you might confront in your practice. Our client is Mr. Smith, and he has a contract with the ABC Company. And the question that Mr. Smith has is the contract enforceable? Maybe he wants to get out of it. Maybe he finds it no longer advantageous, and he thinks it may not be enforceable. That might be the issue. Well, let's say the contract is 30 pages long. Well, probably there's a particular provision or a few provisions in the contract that Mr. Smith thinks may render the contract unenforceable. So it doesn't make sense for you to take a 30-page document and go through every single line of the contract looking for things that might not be enforceable, when really the only part that is really at issue is on page 24, the third paragraph from the top. And you can focus on that particular issue. Also, probably the client, or at least the attorney, has some idea about why it might not be enforceable. so you can focus on the particular issue that is relevant. So the way this is phrased is a very broad question. You'll want to say, well, what are the theories that might not make it enforceable? What sections might not make it enforceable? An example. In other words, under what circumstances can a 17-year-old be emancipated in Texas? Now, very likely this is not an esoteric question. A client didn't walk in and go, I've always been interested to know what the emancipation rules are in Texas. No, almost certainly you have a 17-year-old client, or perhaps you have a parent of a 17-year-old who either wants to emancipate his child or his child wants to be emancipated. And so they're facing a particular set of circumstances. Maybe the 17-year-old wants to marry and the parents don't want him or her to marry. Maybe the 17-year-old is expecting a child. Well, that ultimately results in his emancipation. Maybe the 17-year-old wants to enter the service. So there can be all kinds of reasons why the 17-year-old wants to be emancipated, and it's helpful to know the facts. If the 17-year-old has no intention of getting married, you don't want to waste the resources of your client spending a lot of time researching the rules about marriage and emancipation. So you want to get more focused. It may be presented to you as under what circumstances can a 17-year-old be emancipated, but you're very likely to find that the answer is more fact-specific, and it can help focus your research. Let's look at the next. Is Client Green's relationship with Pat Jones an informal marriage? You may have no idea what an informal marriage is, just so you'll know. It's beyond the course of the scope of this course, but informal marriage is what is oftentimes called common law marriage. And there are three things you need for a common law marriage or an informal marriage in Texas. But you wouldn't know that when you're presented with this question. So you wouldn't know what facts of the Green-Jones relationship you ought to focus in. You might think, well, it's important how long they have had their relationship, or it's important whether they have combined financial resources or something. You may think a lot of things are relevant, but you may find that the things you assume are relevant aren't really relevant, and the facts that you didn't even consider are very relevant. And once you get into the research, you may say, I didn't ask the attorney the right questions. I should have asked this, this, and this, and I asked A, B, and C instead of P, G, and F. So that would be an example of you needing to go back and getting that information. Let's look at the last issue. Client Cruz was injured in an automobile accident. She was speeding at the time. Can she still recover against the driver who ran a red light? I'll just say what the issue is. The issue is comparative negligence. It's part of tort law. You'll learn about this when you take torts if you haven't already. But the issue, if you don't know what comparative negligence is, you wouldn't even know kind of what the terminology is or what's kind of going on here. So it would be helpful to have the attorney, who even if the attorney doesn't know what the rule is in Texas is going to know contributory negligence, comparative negligence, those types of terms. He's going to know that kind of thing to at least introduce you to the vocabulary. And he's likely to say, well, if you really don't know these aspects of tort law, it might be helpful to go to a secondary resource and find out about tort law in general terms, especially as it relates to Texas. There's a very helpful resource in Texas we'll talk about either today or in the next presentation. It's called Texture. And Texture is, here we go, actually short for Texas Jurisprudence. And it's like an encyclopedia of Texas law. What facts are you likely to need for each scenario? And we kind of talked about that to some degree. You may not know what information you need at the beginning of the project, and that's why it's helpful to ask a fair number of questions at the beginning, but sometimes the attorney might say, I'm busy. I don't have a lot of time for this. So sometimes you don't have the luxury, and you might need to review the file at some later point in time. Let's go to the next slide. Finding relevant cases. I said before that there aren't any hard and fast rules about doing legal research, and there aren't. But I would say more often than not, more researchers will start with secondary resources. And let's pause for a second. I'm going to draw a little picture here. There are two categories of resources. We have primary legal resources and secondary legal resources. Primary legal resources are what you and I think of as the law. These are things that someone who is in the government in his official capacity says you got to do this, or you get this benefit, or these are the ways you go about doing this. Examples of this are statutes, the Constitution. I should write on that out. Regulations, treaties, terrible handwriting, I apologize, and also cases, judge decisions, judicial decisions. Secondary resources don't really seem like the law. What they are commentaries about the law, descriptions of the law, recommendations for legal changes, recommendation, and also finding aids. Most of the time, people who create secondary resources are private citizens. Usually they're attorneys or paralegals who are writing documents, and usually they don't work for the government. If they do work for the government, they're not engaging in rewriting the law, but they are simply describing the law. Secondary resources are only valuable to the extent that they accurately describe this stuff. So if I write a commentary, but I misstate what the rule of law is in Texas on this particular issue, I say it is X when it's really Y, then I have created a very crummy secondary resource. It doesn't change the law. I may have misled some legal professionals into thinking the law says X when in fact it says Y, but that doesn't mean that the law has changed. I don't have the power to do that. So I might make a commentary, description, or recommendation that is bad policy, is wrong, is poorly considered, and therefore that secondary resource isn't going to be very good. The quality of a secondary resource isn't who is writing it. In these cases, it doesn't matter that the legislature came up with a stupid law or that the administrative agency came up with a stupid regulation. If it had the power to do it, it's what the rule is. Who cares if they were smart or not? But for a secondary resource, if I do a bad job, it's pretty useless at that point. Another thing the secondary resources often help with is finding the law. It's pretty easy to find statutes, and fairly easy to find regulations, somewhat easy to find treaties. But cases are almost impossible to find without secondary resources, and that's because of the way that cases are arranged. Imagine that you're a judge in 1900 in Texas. So 110 or 20 years ago, you are a judge. And you issue, let's say you're an appellate court judge, you issue an opinion. And in that case, it was a divorce case. Well, that case will be, let's say it was decided January 2nd, 1900. Well, the next day, the Missouri Supreme Court issued a capital murder case decision. And the next day after that, another Texas appellate court issued a case about a breach of contract case. And then a court in Kentucky issued a decision about a dog bite case. Well, guess what? Each one of the cases would be in roughly chronological order. They are not arranged by theme or by court. The reporter that we have in Texas is the Southwestern Reporter, but it covers several other states as well. So it's not just Texas cases. It will have other cases mixed in with it, and they aren't arranged thematically. So you'll have a divorce case next to a capital case, next to a breach of contract case, next to a DWI case, next to a tort case, next to a probate case. All kinds of cases in all kinds of order. Well, you can imagine if you're trying to research what is the law about dog bite cases in Texas, you would have to look, at least briefly, at every single case. And this is, thousands of volumes of cases to find it. So you would have to spend probably thousands of hours to find out what the law is in Texas on dog bite cases if you didn't use any secondary resources. That would obviously be tremendously inefficient, and there are lots of finding aids that will help you find the relevant dog bite cases. So you use the secondary resources to find the primary resources. So let's go back. to talking about the secondary resources. And as I said before, they will describe the law and they will also help you find the law. So that's why it's helpful to use them. First, the descriptive aspect of it are helpful because it helps you, particularly if it's an area of law that you're not familiar with, it helps you understand kind of the general lay of the land, maybe to learn the vocabulary, maybe to get some major cases in this area, to get a framework, a mental framework to see what the cases are talking about. And then, of course, finding tools help you find the statute or important cases, and so point you in the right direction. There are kind of two categories of ways to approach legal research. The first is the book research approach. This is the one that I would say up until the early 1980s was the way all research was. I mean, there really weren't computers available to do any of the type of research. I started law school in 1987, and I graduated in 1990. And at that point, legal research was available online. Both Westlaw and Lexis were available. But they were in their fairly early stages, and they were very, very expensive. And they're much cheaper now. So at that point in time, lots of people still did book research. In fact, doing online research because of the expense factor was really something that was out of the budget of many, many clients. So I learned when I was practicing, or when I was learning to practice, both the book research style and the online research approach. You will also learn both. Our legal research course does involve both book work and online research. But I will tell you that because of the reduced cost of online research and because of the increased amount of material that's available online, and because online research has become so much more popular and the books have become even more expensive, more and more legal professionals research online, either exclusively or usually. And so, yes, we will introduce you to book research, but we will spend in the legal research course probably more time on online research than on book research, simply because unless you work for a big law firm, there probably won't be a very robust physical law library for you to turn to. You'll have online tools that will get you where you need to go, but if you're going to rely upon books, or if that's the way you've learned how to do it, you may find it difficult to practice in a law firm environment. Now, there are still places to see the books. The Collin County Courthouse Law Library is open to the public. It's in the basement of the courthouse in McKinney. It's a very lovely, robust library. And so, particularly if you are working for a small law firm that perhaps doesn't have the best cash flow yet, they may say, well, we can't afford the online tools yet, or at least not routinely afford it, and so we want you to use books. And so that is one place that you can go to find out many of those answers. So it's not that the book research isn't important, it's just it's probably more important nowadays to do the online research. And certainly 10 years from now, the trend will even be more so toward online research. Let's talk about legal encyclopedias. Here are some common ones. These are talked about in the textbook. The first is AmJur, and you can see it's AmJur. I told you about Texture already. Texture is the Texas version of American jurisprudence. Little funny story about Texture. When I was beginning my practice, in fact, it was before I'd actually been admitted to practice law. I was working for a law firm for a summer, and an attorney referred me to Texture. Said, well, I think you ought to start looking for the answer in Texture. And that was very smart advice from the attorney, because he knew I didn't go to law school in Texas, so I wasn't as familiar with the quirks of Texas law, and this was kind of a good introduction. Texture and AmJur are both kind of like the Encyclopedia Britannica of the law area. They give you a relatively easy layperson almost level of knowledge about the law. It's very kind of easy peasy approach. Doesn't get you very deep into it, but lets you kind of know general concepts. And so the attorney referred me to Texture. Well, the way people pronounce Texture is like this. Texture. That's what I heard. Now, I don't know if I was arrogant or perhaps I was too shy or whatever, but for whatever reason, when I heard Texture, I didn't ask any questions. I assumed that there was some book called Texture, maybe with a capital T here, or maybe the author's name was Texture. But of course, I heard Texture. I assumed it was this word right here. It didn't even occur to me that it was short for Texas Jurisprudence. I knew about AMJUR, but this is a national publication, but I didn't know about Texture. And so I was looking through the stacks to find this book called Texture. Well, I was working for a big law firm that had thousands of books in its library, and I wasn't finding it. Now, I walked past Texas Jurisprudence a dozen times, but of course, Texas Jurisprudence says Texas Jurisprudence on it. It doesn't say Texture, so I kept on walking. And so I got myself confused as a result of that. So the takeaway is ask questions. Sometimes you don't know what to ask, but if you're saying, hey, I can't find this book, am I looking in the right place? Is it an abbreviation for something, or is it a term that people use that might not be the name on the book? And there's a lot of that in the law. The next one is corpus juris secundum, which is called CJS. Almost no one says corpus juris secundum. So they'll call it CJS, and if you were looking for it and you saw this on the spine of the book, you might not relate it to the initials. Now, it's rare that a law firm is going to have the CJS. AMJUR, Texture, they might have, but this is not as common. But it performs much the same function. It is a national encyclopedia of the law. Words and phrases, it's even less likely that your law firm will have this. If you were to go to the SMU Law Library, you'll find this. Words and phrases, to me, sounds like it should be a dictionary, but it's not. What words and phrases has are phrases, or sometimes just single words, from opinion. So let's say you want to see how the phrase res judicata has been used in cases. And so what you do is you look up res judicata. This is the word, res judicata. And it would show you cases, prominent cases that have used the term res judicata. Now, and it would take the parts of the case that actually have this phrase. Now, it might be in some of these cases that the court actually defines what res judicata is. Other times they might just use the term, assuming that the reader understands the term. So, yes, there can be definitions, but it can also just be looking for context clues. So it doesn't function as a dictionary. Another thing to keep in mind are pocket parts. I'll clear this out for a second. Imagine a book here. Great artist, as you can see. And we have here are the pages with the text on the pages. And let's say you read this line right here and you say, oh, that's exactly what I need to know. But you know what? When this book was published, the author of this book thought that this information that he wrote was exactly right. But it could be that the day after this book was published, the law fundamentally changed in this area. Well, the book's already been put into law libraries. It's prohibitively expensive to think that the publisher is going to come in and say, oh, wait a second, we need all those books back, we're going to have to republish them. No, that's not what's going to happen. Kind of an errata. You may have seen this in newspapers. An errata could be printed, except they don't call it an errata. And actually, it's usually not for errors. This is for changing the law. When the guy wrote this phrase, he was correct. It just so happened that the statute was changed the next day. It ceased to be correct, but when he wrote it, it was correct. So what you have to do is you have to look at that pocket part. So if you look at a book and you open it up and you flip all the pages to the front, so you're staring at the back inside cover of the book, there will be an insert here, and this is called the pocket part. Sometimes it's just one page, sometimes it's 300 pages. If the book was published for the first time a year ago, the errata page there may be no pages, or it may just be a few pages. If this book was published 20 years ago, you might have a pocket part that's 200 pages long. Anyway, so this is a little insert in the back of the book. Sometimes pocket parts, though, are actually freestanding books. You might have the book here, and then you might have a soft-bound book next to it, which functions as the pocket part. So it's still called the pocket part, or maybe the supplement, even though it's not in the pocket. Of course, at some point, if the pocket part gets too thick, the binding of the book won't be able to handle that. So it's always important to check pocket parts. Never feel like when you're looking at a book that you're done until you've checked the pocket part to make sure there hasn't been some change in the law. Let's talk about case digests. Case digests are so helpful in finding cases. I gave the example before about us researching Texas law on dog bites. And we really don't want to look through thousands and thousands of cases to find that needle in the haystack, those handful of Texas cases that deal with dog bites. So how are you going to go about finding it? Well, in Texas, what you're going to use is Texas Digest. This is a digest system published by West Publishing. We'll talk more about West in legal research, but we'll touch on it here. And what this does is it has organized the law, not just Texas law, but all states' law, into number system. And it's broken it down into more than 100,000 different bites of the law. So it's not just that all marital law is under one topic, but there might be thousands of subcategories within marital law. There might be thousands of subcategories on contract disputes. And so you look through all the different categories to find the one that is relevant to your case. Let's say you're focused on what is an informal marriage in Texas. Well, you're not interested in how to get a divorce. You're not interested in how to get an annulment. You're not interested in property division. You're interested in what is an informal marriage. And they're going to have one or more numbers about that particular topic. Well, you'll go to the Texas Digest that includes that particular key number, and you will find the cases that talk about that issue. If you're, again, researching a dog bite, you'll find the key number or numbers that talk about dog bite cases. And it'll point you to the 10 or 20 or however many cases there are. They'll point you to the case that was from 1910. It'll point you to the case that was in 1927. It'll point you to the case that was in 2004. And you won't have to look in 1912, because there weren't any cases in 1912, or 1913, or 2003, or 2010. So it's a tremendously easy way for you to save time. Now, it'll point you to the cases, and it'll even point you to the section of the opinions that talk about it. But you actually have to be the one who reads it and decides that, what it means and how to apply that to your particular research. So it points you in the right direction, but it doesn't really give you the answer. And as I say, the digest is very much tied to the key numbering system and assigns numbers to all legal topics and subtopics. Within an opinion, there will be headnotes at the very beginning of the case. These are not headnotes are not produced by the judge who authors the opinion. The judge just authors the opinion. But West editors will go through and read each one of these opinions that's going to be published and find out all of those topics and subtopics that are talked about. And an opinion might be focusing, for example, on what is an informal marriage, but it might also have some appellate law issues, or it might have some issues about community property that it briefly touches upon. And so it will list all the different topics that are covered, and it will show the assigned number. And that allows West to then correlate that information that is developed in the headnotes for each case and incorporate that information in the digest. So if there's a headnote about animal bites or dog bites, because there's a headnote about that in that case, that will correlate to the Texas Digest entry, and you'll be able to find that case. You can also use, in addition to Texas Digest, which is a book version. It's kind of a bright blue, kind of this color, blue book. But you can also use the key numbers with Westlaw, which is an online research tool, which you will have access to when you are in legal research. There are lots of digests. There's a Federal Digest, American Digest. There's also Texas Digest, which is a state digest. Texas is a big state, and so we have our own digest. If you were dealing with a less populous state, you'd probably share a digest with other states. Then there are also specialized digests. For example, employment law digest or something along those lines that deal with a particular issue but would cover several different So that gives you an overview. Digests are very useful tools to finding cases. Another useful tool is oftentimes called ALR. It actually stands for American Law Reports, but I will tell you, lots of legal professionals will just call it ALR. They may not even remember the official name of it. ALR volumes contain both primary sources, actual judicial opinions, and secondary sources, analysis of those judicial opinions, references to the various statutes in various states. Imagine for a second that there's a new big abortion rights decision that comes down. Well, that decision might be published in ALR, and then there might be a related kind of law review article that goes through the law in all 50 states on abortion. Maybe talks about the development of the law relating to abortions from maybe even the 1800s to the current law. May talk about the law about abortion in other countries, what's the law in Canada and England and Japan and Mexico. It may talk about trends in the law or what is anticipated developments will be in the future. It may talk about attempts to change the law and whether they've been successful or whether they're likely to be successful. So it's a combination of primary sources and secondary resources. I'll tell you, most people consider it primarily a secondary resource because the actual cases that are published in lots of different other resources, and it's pretty rare that somebody actually goes to ALR to find the primary resource. They're there for the secondary resources. But there are other secondary resources. There are things called treatises and hornbooks. Your textbook is a treatise or a hornbook. That's really any publication that describes the law. So a textbook would fit into that category. Things like, I guess the most famous is Prosser on torts. Prosser passed away now, but Dean Prosser was a tremendously respected law professor, and he wrote a book on torts. And because it was, of course, the name of the book was Torts, but it became so synonymous with him that people call it Prosser on torts. And now it's called Prosser and Keaton on torts because Dean Prosser has passed away, and Mr. Keaton is now the maintainer of the book. He's also well regarded, but doesn't quite have the stature of Dean Prosser. So that name, even though it's a secondary resource, which doesn't have any binding aspect to it, it's not a statute, it's not a case, it's not a regulation, but because that is so respected. If you were to cite that to a judge, it's a rare judge that's not going to be highly inclined to apply the rule that Prosser describes because they know Prosser gets everything right. But if I were to write a book called Groover on torts, well, a lot of judges would say, who's this Groover? I don't know this Groover. Maybe she got some things right. Maybe she didn't. They're not going to be impressed by you citing a book like that. So the takeaway is that treatises and hornbooks are useful to cite, but the reputation of the author is important. And if an author doesn't have a particular reputation, they can still be cited, but you're really going to have to or the strength of the argument that the author is advancing is what's going to save the day. If he or she isn't presenting a strong argument, it doesn't really, don't bother citing it because the fact that some publisher somewhere decided to publish it isn't going to persuade a judge. He has to believe either this person has a lot of gravitas or, wow, he finds the argument very compelling. So really and usually treatises and hornbooks are a single volume or maybe a 2 or 3 volume set. Lots of areas of the law have their specialized hornbook. An example in family law in Texas is the Coons book, which I don't even know what it's called. Many times these books are referred to by the author's name, and his name is Coons. I think it's Don Coons. An example, I practiced in employment law for several years, and one of the go-to books, it's actually a series, I think it is 3 volumes, but that's Schley and Grossman. And again, I think it's probably called employment law, but the 2 authors are what people call it, Schley and Grossman. They're kind of a forest green book. And so if I were to refer to it with someone, I'd say, have you looked in Schlein Grossman? And people who practice in my law would immediately know what I'm talking about. People who do tax law would be like, Schlein who? What are you talking about? So you only know the go-to books in your particular practice area. And very likely you'll practice in one or two areas primarily, and you'll know what are the go-to books. But just be aware that there may be some resources out there for you. Another thing to think about is the restatement of the law. Restatement of the law can be a very useful tool. We've talked about case law a little bit, and we've talked about how hard it can be to find. But even if you find all the cases, and let's say this is that dog bite issue, you've found all the cases, and you found, gee whiz, in Texas, I'm making this up, I have no idea, but let's say that there are 10 big cases. And you read them, and they each take a little bit of a different spin. They were written by different courts. They were written in different generations. They have different facts. And so it's a little bit like a jigsaw puzzle. The pieces probably don't fit exactly perfectly together. I'm not saying there's huge holes, but there's going to be some areas of an imperfect fit. This judge isn't going to, let's say this case from 1910 in Eastland, and this is 2009 in Dallas. There's probably going to be some areas, maybe very subtle, of disagreement there. And so you're trying to resolve all these tensions, and you can see how that can be a pretty tricky approach. Well, you still have to do that in the practice law, but one tool that is sometimes helpful, not always, but sometimes helpful, are restatements of the law. What a restatement is it's produced typically by law professors or by very well-respected attorneys. And what they do is they read all these cases in their particular area of expertise, and they pretend that they're acting as a legislature. And they translate what these 10 cases or 20 cases or 5 cases or whatever the cases are, they translate the legal doctrine in those cases to something that looks like a statute. They're not going to change the law. It's not their goal to say, oh, all these judges, they're wrong. This judge was wrong. This judge was wrong. No, they're not reforming the law. They're just describing the laws that exist. They may agree with it. They may not agree with it. But their focus isn't on was the law correct, but simply describing the law. And they write it as if they were writing a statute, a law, something the legislature would pass. And as you can imagine, if you review that statute, that restatement of the law, that fake statute, that distills what these 10 cases say into maybe a page or less of text, boy, that can be tremendously handy. Now, it's not a cure-all. For one thing, it is a secondary resource. The authors of these kind of fake statutes aren't members of the legislature, so if they get it wrong, if they don't give G enough weight but give a lot of weight to D, then the judge can say, I don't agree with that restatement. That's not good. Plus, restatements are national. And while the common law is similar across state boundaries, there are subtle differences between Texas common law and Oklahoma common law and Massachusetts common law and Washington state common law. So you might find that the restatement is a fair description of most of the common law in most of the states, but it doesn't capture the quirks of your particular state. So there are some aspects of the restatement that can be problematic, and certain restatements have a better reputation than others. But I want you to be aware of that tool. It's probably not tremendously commonly used, but it is out there, and it can be a good resource sometimes. A common, probably more common resource to use are legal periodicals and bar journals. Being a member of the Bar Association entitles attorneys to the bar journal that the state bar produces. And in Texas at least, it comes out once a month, and it is a magazine, kind of like a U.S. News and World Report or something like that, or Time magazine, about that level of thickness. And it covers many different things, but one thing it does is it tries to give 2 or 3 page articles about very practical help for attorneys. What do you do when your client does X? How do you respond when this situation arises? And there are other articles about, what's the best technology for our law firm, or how do we handle this accounting issue, or things like that. And then there are articles about law, or bar association business, and information about disciplinary proceedings in front of the bar association. Lots of different things, but you can see how those bar journal articles can be very practically helpful. Telling you what you need to know, especially useful for the general practitioner who dabbles in a lot of areas of law but perhaps isn't an expert in any particular area, or at least in the particular area that he's now confronted. Similarly, there are other legal periodicals usually produced by law schools. Most law schools have a premier legal periodical, oftentimes called the Law Review. For example, the University of Texas has a law journal called the Texas Law Review. It is the most prestigious of the reviews that University of Texas Law School produces. My guess is, though, because University of Texas has such a large law school, that they probably have several other secondary journals that are produced that are much easier for students to be involved in producing. These journals, especially the most prestigious for the law school, produce articles typically by law professors who are trying to publish, many times trying to get tenure, and so they publish articles about the current state of the law, trends they see developing in the law, or recommendations for how the law ought to be changed. We will talk a little bit about, or we will more than a little bit about it when we get into legal research. We'll talk about the very technical, formal ways that law review articles have to be formatted and that kind of thing. But the takeaway for you to have at this point is simply that these law journals, these law reviews, oftentimes will give you information about trends in the law, developments in the law, and many times they can be, especially if they're from a prestigious law journal like Texas Law Review, they can influence the thinking of a judge. Now again, they're still a secondary resource. The law professor who wrote it is not a member of the state legislature, isn't a judge, so he or she doesn't have the force of law behind him, just the strength of the arguments that he or she is advancing. And let's look at the last item, which is law dictionaries. By far the most name-recognized law dictionary is Black's. The current editor of Black's is a gentleman by the name of Brian Gardner. He is actually local. He has quite a reputation in the legal business for legal writing. When you take legal writing, you may well hear information about Brian Gardner. And we will talk about some of his approaches to legal writing when we get to Chapter 8. But for now, we're really just focusing on the fact that he is the editor of Black's Law Dictionary. Interestingly, Black's Law Dictionary is not always black. The copy I have, for example, is kind of bright blue. But when they use the term black, of course they're not referring to the color black, but I guess at some point somebody's last name was Black, and he wrote this law dictionary, kind of like Webster's dictionary. There's another one that is also well regarded, and that is Ballantyne's. Both Black's and Ballantyne's are well regarded, but they don't come inexpensively. There really is no need for you to go out and purchase a copy. And if you were to find an inexpensive one at half-price books or something like that, I wouldn't discourage you from buying it. But once you get pricing in a law firm, it's very likely you will be given or loaned or have access to a fine legal dictionary. And so probably it's not something you necessarily want to buy yourself. We have several copies in our library on the Spring Creek campus. Sometimes they have them not on the shelves because there's been some tampering with the books. You might need to go to a reference librarian to get assistance in accessing it. But it's a useful thing to have some familiarity with. In the meantime, you may want to use the index and the dictionaries available in your textbooks, as well as online dictionary tools. And I'll talk more about online resources that are available to function as legal dictionaries when you are in the legal research course. So that's some information about legal dictionaries. In our next presentation, the second half of Chapter 6, we will cover the case reporting system and go on from there, Chapter 7 to the end. I hope this was useful for you. Thank you for your attention, and I hope you have a great day. Thanks. Bye-bye.